So now that it's 6 o'clock, I think I can say good evening to everybody here. My name is Michael Bridge. I am in the curious position as a visitor of moderating this event on behalf of the University of Hong Kong, and it's a great pleasure for me to do so. I am an emeritus at both the London School of Economics and the National University of Singapore. And in case you're interested, I might be starting to work on a third campaign to see if I can ever acquire the status of a third emeritus professor. That may be unduly optimistic. Anyway, it's my great pleasure to introduce now Dr. Adam Waldman, who's going to talk to us about codification and how it has an effect upon the endemic common law, whether you can take a statute and drop it down in the middle of a legal system without imagining that there will be some kind of fallout or turmoil. How do you fit the two together? I have a long-standing interest in secure transactions, as do other people in this room. And I'm very interested in what Adam has to say. There has always been, when it comes to Article 9 and its congeners, something rather religious about the subject, as though we are now dealing with a new creature. It has its own theology. All previous beliefs can be cast aside. We now have, as it were, tabula rasa. And I think Adam is going to tell us that that is a profoundly misconceived view. So without any more, over to you, Adam.
Thank you very much. So my talk this evening is entitled The Limits of Codified Secured Transaction Statutes. Why does the common law persist? And what I plan on speaking on are what I'm going to term functionalist secured transactions statutes. That, admittedly, I should say from the get-go, is just such a mouthful. But for reasons I'll talk about, I don't think it's right to call them codified statutes. And it's impossible to otherwise talk about them without adopting some kind of a bent towards one jurisdiction or another, because all of the jurisdictions which have enacted these statutes, including my own in Australia, can't quite seem to agree on exactly what they should be called. Now, I appreciate there's probably a divergence in terms of expertise and background knowledge on these types of statutes, particularly given Hong Kong, like England and Singapore, are jurisdictions which do not have this type of statute regulating personal property securities law. So I just want to spend the first couple of minutes giving a broad outline of what they are, how they work. The idea of a functionalist secured transactions statute is that it is built on this notion of what we can call either functionalism or substance over form. And at its core, there are two ideas within that. The first is that what these statutes do is they take a range of property interests, and regardless of the common law form of those interests, if they have the function of securing an obligation, they are characterized as a security interest. Now, that encompasses the interest that we would traditionally think of as security interests, such as mortgages or charges or pledges, but it also encompasses any other property interest with a similar function, including the interest of a seller of goods on reservation of title terms, and also in some instances, including the interest of a lessor of goods. Now, once an interest is characterized as a security interest, which I put as step one, step two of these statutes is that they then apply a uniform set of rules to all security interests, and those rules do not delineate based upon their common law form. That's ultimately what these statutes entail at their core: characterize lots of property interests as a security interest, and then just apply a uniform set of statutory rules to all security interests. Now, I should mention, although it's not the focus of what I want to talk about tonight, that within these statutes, it's necessary to take steps to perfect a security interest. And typically that occurs by way of registration. And the registers under these statutes are not the type that we might be familiar with. They're what is known as a notice filing register. So you don't register the existence of your security interest, what you typically register is essentially it's like putting a sticky note on a notice board that says, I might have a security interest in said property. Now, returning to the more conceptual point, obviously this is quite a different approach to the way that the common law and the various statutory overlays on the common law regulate the law of secured transactions. So the key obvious difference is that under a system like the English law system, whether you need to make a registration in respect of a security interest, if it's granted by a company, depends on whether it's characterized as a charge or not. And that, of course, gives rise to a fairly large body of law as to what is and what is not a charge as so defined in the Companies Act. Under one of these functionalist secured transaction statutes, once you're in the statute, you must take steps to perfect, including making a registration where appropriate. And so it no longer matters what the form of your security interest is. The history of these statutes originates in the United States. They began in Article 9 of the Uniform Commercial Code, which was enacted or was first passed in 1952. They were then picked up by each of the Canadian common law provinces between the 60s and early 2000s, and in turn by New Zealand and Australia in 2002 and 2009. And I think the last thing it's important to be aware of by way of background is just that there has been, and to some extent continues to be, debate over whether such a statute should be adopted in other common law jurisdictions. In English law, there have been a series of reports over approximately the last 50 years. Some of those have recommended enacting this type of functionalist secured transaction statute, but that has never been effected, particularly due to especially strong opposition from the City of London lawyers and the banking lawyers in London, who in essence have said, look, our law of secure transactions already works fairly well, and we think the way to improve it is to make small changes rather than a kind of enormous wholesale reform that is entailed in enacting these types of statutes. Okay, there's a background out of the way. That brings me to what I hope is kind of the more interesting and less descriptive stuff that I want to talk about tonight. What I want to do in this talk is explore the limits of the functionalist approach adopted within each of these types of statutes, and in particular explore why it is that the common law continues to play a really important role in informing how they work, despite the fact that the whole idea underlying them seems to be doing away with some of the consequences of common law form. Why would you care about this in a jurisdiction like Hong Kong? Well, the analysis tonight will inform two questions, and I think they are related. The first is whether this sort of a statute is worth enacting in a jurisdiction such as Hong Kong, which has an English law type law of secured transactions. The second question that this informs is, if you are going to go down that path, what are some of the things that should be thought about and that perhaps deserve more thought than they have received in jurisdictions such as Australia, Canada, and New Zealand when it comes to enacting one of these statutes? Now, because this can be a very technical and dense area of law, I'm going to do my best to kind of confine myself to trying to just make 3 points this evening, each of which I'll illustrate with a single example. The first point that I want to make, as Michael has already alluded to, is that these functionalist secured transactions statutes are not codes. And when I say they're not codes, I mean that they're not codes either in the civilian sense of that term or in the sense in which we use the term to describe a codification of the law in common law legal systems. The second point, which flows from that, is that the approach on which these statutes are built, this idea of substance over form or functionalism, it does not resolve many of the policy choices that have to be made when you are enacting this type of a statute. And it follows that there are lots of choices that really just need to be considered on their own merits, rather than based upon the misapprehension that functionalism is some kind of magic solution in and of itself. The third point is that functionalism does not do away with formalism in a more general sense. When we talk about this notion of substance over form, it can lead us to think, well, great, that does away with formalism, by which I mean the sense in which the law can require technical fine distinctions and then attribute significant legal consequences to those technical fine distinctions. And so the last thing that I want to show is that functionalism does not and cannot do away with the need for that type of reasoning. All right. Let's start with my first point. Functional secured transaction statutes are not codes. Now, to illustrate this, the example that I want to use comes out of the definition of what is the key concept underlying these statutes, the security interest. Like I said, it's the security interest that kind of gets you into this statute. First, it says, is there a security interest? Secondly, if so, it applies a set of rules to that security interest. Now, under these statutes, there are two types of security interests. There's the one I've spoken of, which we often call the in-substance security interest. That is exactly what it sounds like. It's an interest in personal property that secures an obligation. I should also flag, although I don't want to get into it, that these statutes typically deem some other type of property interests to be security interests, even where they don't have a security function. So, for example, certain long-term leases of goods will be deemed to be a security interest, and then the rules of the statute will apply to those interests. For present purposes, if we just focus on that in-substance security interest, the one that really underlies what these statutes are all about, the requirement within the definition of the in-substance security interest is that not just that it secures payment or performance of an obligation, but also that there must be, to begin with, an interest in personal property. And those words, an interest in personal property, should be interpreted exactly in the sense in which you would expect them to be, as requiring what we would understand at common law to be a property interest. Now, it follows from this that for there to be a security interest, there must be an interest in personal property. And for there to be an interest in personal property, we need to fall back on the common law understanding of what an interest in personal property is. As you're, of course, aware, the way in which we say whether there is a property interest at common law is by asking whether it falls within one of the recognized forms of property interest. Is it a bundle of rights that constitutes, for example, a mortgage or a charge or an ownership interest? And if not, the approach of the common law is, well, okay, you can contract for that bundle of rights, but we won't make it enforceable against third parties. The consequence of this is that to say whether you have a security interest and thus to get into the statute that tries to do away with the consequences of form, we first need to be able to say that there is a property interest which turns upon common law form. That was a mouthful of a sentence, but the point that I'm getting at is that common law form is essential to these statutes at the very outset. Now, the next and related point that I want to make is that this is not just kind of a drafting quirk, and it's certainly not what you could describe as poor drafting of the existing such types of statutes. My focus is largely on the Australian, Canadian, and New Zealand statutes, but there are others, including, of course, that of the US. The reason why it's not possible to just draft your way around this is that even though in theory we could kind of reinvent property law for the purposes of a secured transaction statute, that would, of course, lead to all sorts of inconsistency in other areas of law. Most importantly, if we were to kind of tweak what it is that is a property interest under a functionalist secured transaction statute, that would work within the confines of the statute, but then could create significant problems when you come to an insolvency law context, where whether an interest remains enforceable in insolvency continues to depend upon our common law understanding of property law. And so what I'm getting at here is that unless you're going to engage in a complete reform of how property law works and what is a property interest for all of the law of personal property, it is inevitable that these types of statutes must continue to draw upon common law form to say whether you get into the statute to begin with. Now, in the written paper on which this is based, I go through many other examples. If I was to kind of quickly flag two, I've mentioned that there are these other types of security interest, deemed security interests. The point that I would make here is that each of the deemed security interests under any of these statutes, they are defined by reference to particular types of property interest. So to say that a lease gives rise to a deemed security interest, we need to understand what a lease is, and thus we fall back on our common law understanding of what a lease is. And the same is true for any other such types of interests. And thus, common law form is essential to getting into this statute to begin with. The other point which I make in the paper, which I won't elaborate on now, but is that common law form is not just about getting into these statutes. It also continues to play quite an important role when we apply the rules of these statutes. So the example that I make a passing reference to concerns a purchase money security interest, which the Australians and New Zealanders tend to call a PIMSI. I'm told that's because of the kind of New Zealand accent that happens when you try and say PIMSI, which in turn the Australians have just picked up. A PIMSI is a kind of further subcategorization of a security interest, and it's one that, for policy reasons we won't talk about now, can sometimes have super priority over other types of security interest. Now, to figure out whether a security interest is also a PIMSI, again turns on various requirements which themselves pick up on different ideas of common law form. And this is just one of many examples that show common law form continues to permeate these statutes, both in whether they apply to begin with, and then indirectly in how many of their provisions continue to apply. Two conclusions flow from this. The first is that which I've kind of put quite forcefully at the outset. A functional secured transaction statute is not a code, and it is not a codification of this area of law. We can only make sense of these statutes by continuing to understand common law concepts which are not in terms restated in their texts. Something I often like to point out when people are first encountering these statutes. So when I teach these to Australian law students, I often do it in 2 3-hour lectures, and I spend the whole of the first 3-hour lecture just teaching my students about the different forms of common law property interests, because they first need to understand what we mean by a mortgage or a charge or a pledge, and they need to have an idea of how it works to sell goods on retention of title terms before they can understand whether they have a security interest to begin with. Now, the second point that in turn flows from that is that we need to think of functionalism or substance over form slightly more narrowly than sometimes people tend to think of it. For the reasons I've just discussed, substance over form does not and cannot involve doing away with all of the consequences of common law form. What it instead entails is just applying a uniform set of statutory rules to a variety of different common law property interests. Or if I try and put that even more simply, all it entails is that we apply the rules of the statute to all security interests without directly delineating based upon their common law form. Now, that seems like a finicky distinction. Let me get into my next 2 points where I'll hopefully show why it is also an important distinction. The second point that I want to make, as I adverted to earlier, is that functionalism, or this substance over form approach, cannot resolve policy choices that need to be made within these statutes, including many of the choices that arise because of the ongoing influence of common law form as to when they apply and how they work. The example that I want to talk about here concerns whether a security interest must be a legal interest or an equitable interest, or perhaps whether it might be either, depending upon its underlying common law form. Here again, it's necessary to give some background as to when this continues to matter. So these functionalist secured transactions statutes contain a comprehensive set of rules which regulate most priority competitions. In particular, there is a comprehensive set of rules that regulates what happens when one security interest comes into competition with another security interest. And those rules don't turn upon the legal or equitable nature of these security interests. They instead turn upon typically the time of perfection or registration and whether any of those security interests have super priority. And thus, whether a security interest is legal or equitable is not at all important for a competition between multiple security interests. Similarly, whether a security interest is legal or equitable no longer matters for what happens when someone buys or leases property that is subject to a security interest. When someone buys property subject to a security interest, that is again governed by a comprehensive set of rules, which are called the taking free rules, and whether that buyer takes free of the security interest is determined without reference to its legal or equitable nature. Now, having said that, there are limits to the scope of these rules. A point that's made by Professor Roderick Wood, who's an academic in Canada and was one of my PhD examiners, is that it is not possible to draft a set of priority rules that is so comprehensive that it governs every possible property interest that a security interest might bump up against. And the consequence of that is that there are some competitions which continue to fall outside of the scope of the statute, and thus for which we need to return to our common law priority rules. I tend to call those interests non-PPS interests, a non-personal property security interest. And so the question then becomes, where you have a competition between a security interest on the one hand and a non-PPS interest on the other, must the security interest be legal or equitable or either for the purposes of that competition? And I should flag, to give this some more kind of content, the most important types of such non-PPS interests that we're thinking about here tend to be beneficial interests under trusts, equitable liens, other equitable interests, such as the equitable interest of a tracing claimant into traceable proceeds. And the other one that's come up a little bit more in the Canadian cases, competitions between a security interest and a statutory interest arising under a different statute. It's these types of competitions where it remains important to say, well, what is the legal or equitable nature of a security interest? Now, I've already covered this, but essentially there are three different options that we might choose between here. We can say all security interests must be legal, all security interests must be equitable, or a security interest might just retain its common law, legal, or equitable nature. Now, this has been heard and considered in a handful of cases, or not quite a handful of cases. There have been 4, 2 in Canada, 1 in New Zealand, and 1 in Australia. In none of these cases was a contrary view argued. In 2 of them, it made no difference to the outcome. But nonetheless, each of the 4 cases to have considered this issue have said that a security interest must be a legal interest. I've put 2 up there on the slide, the 2 Canadian decisions, both of the Supreme Court of Canada. So innovation credit concerned a competition between a security interest that would have been characterised as a floating charge and thus equitable on the one hand, and a statutory interest arising under the Canadian Bank Act on the other. And the Supreme Court of Canada said the security interest is legal, and thus, because it was created first, it had priority. iTrade was a competition between what, in English law terms, we would say is the equitable interest of a tracing claimant on the one hand and a security interest on the other. And again, the Supreme Court of Canada said, since the security interest must be a legal interest, it had priority. Now, the reasoning underlying that conclusion in both of these cases was that the substance over form approach requires all security interests to be legal interests. And I do think that is to some extent intuitive, right? It's easy to say, well, okay, substance over form, we need to treat all security interests in the same way. And if we're treating them all in the same way, we should treat them all as legal interests. The difficulty with this, though, is that as we've spoken about, this overstates what the substance over form approach actually entails. As we've established, substance over form is not about treating all security interests in exactly the same way, nor is it necessarily about doing away with all of the possible consequences of common law form, which is impossible. Substance over form is just about saying we want to apply the same statutory rules to all different types of security interests. Now, when we appreciate that, it becomes clear that that just has nothing to do with whether a security interest should be legal or equitable when you fall outside of the scope of those rules. So if I try and put that another way, if the proposition is that we must apply the same statutory rules to all security interests, that says nothing as to what happens to those security interests when we are not applying those statutory rules. Instead, what I want to suggest is that this question, whether a security interest must be legal or equitable, is one that needs to be approached as a question of policy, separately altogether from the substance over form approach. When we view it that way, the question looks a little bit different. I think it boils down to a trade-off between simplicity on the one hand, in that it is easier to just say all security interests are legal or equitable, don't worry about what their common law form is. On the other hand, there is a cost to this, which is that what we are inevitably doing is either strengthening or weakening the position of parties who are in competitions with security interests. So again, if I can illustrate with what I think would be a typical example, if you have a competition between a trust beneficiary on the one hand and a party that holds a security interest on the other. Now, if we say that all security interests must be legal in nature, that will convert some equitable security interests to legal ones. And that will in turn mean that the trust beneficiary will be worse off in some priority competitions, as was the case in iTrade. And the same is true if we kind of flip that the other way around. If we say that all security interests must be equitable interests, well, the problem there is that those parties who would have held what we would have said is a legal security interest are now in a worse position when they come into competition with a party such as a trust beneficiary. Ultimately, my point is not really that there is a right answer here. I can see it being perfectly acceptable for different jurisdictions to make different decisions as to whether simplicity on the one hand is worth that trade-off of changing the rights of these parties that remain governed by priority competitions of the common law. But the point that I want to make is that it would be wrong to make this decision based upon substance over form, because substance over form just sheds no light as to what the right answer is. Now, in the paper, again, I talk about several further examples. Perhaps, thankfully, we won't go into them now. But the point that I want to emphasize is that this proposition is true more generally. There are lots of different policy choices that need to be made within the enactment of these statutes. Many of those policy choices arise from the ongoing interactions between these statutes and the common law, and they just give rise to really knotty, difficult problems, sometimes to which there is no necessarily right answer. There are just trade-offs that have to be made. And the point that I want to emphasize is that in making those decisions in enacting this statute, we should be focusing closely upon what those trade-offs are. We should not be making these decisions based upon a misunderstanding of what substance over form or functionalism actually involves. That brings me to my third and final point. And this concerns what I think we can think of as the other limit of this functionalism or substance over form approach, which, as I said earlier, is that it does not do away with the notion of formalistic reasoning. Now, as we're of course aware, common law legal systems, and in fact, although I know very little of civilian law, I think it's probably true of all legal systems, we will often draw very fine technical distinctions and then attribute significant legal consequences to those technical distinctions. At first glance, it's easy to think to ourselves, substance over form, that must get rid of these formalistic distinctions. And once again, the point that I want to make here is that when we appreciate the proper scope of substance over form, we can see that it just has nothing to do with formalism in a more general sense. Substance over form is about removing some of the consequences of the common law form of a property interest. That is entirely separate from the notion that law is formalistic. The example that I want to use to illustrate this concerns what is often termed statutory tracing under these functionalist secured transactions statutes. It seemed like a good name in the written paper, but I must say it's a real mouthful when I'm trying to get through it in the talk. Now, the way that these statutes work is that they provide where you have a security interest in property, and that property is, for example, sold and replaced with cash proceeds, your security interest will be enforceable against the proceeds of the original collateral. The way in which proceeds is defined is then fairly complex, but one of the requirements of whether one piece of property is proceeds of the original collateral is that the proceeds must be identifiable or traceable personal property. The question that this then raises is whether that should be interpreted by reference to the rules of equitable tracing. In other words, when collateral is sold and replaced with a substitute, will that substitute be proceeds based upon the equitable tracing rules, or should it be determined whether it's proceeds based upon some other set of statutory tracing rules? Now, the leading case on this is a decision of the Saskatchewan Court of Appeal called Agricultural Credit Corporation of Saskatchewan and Pettyjohn. This case concerned Mr. and Mrs. Pettyjohn, who were farmers. They were cattle farmers. They had granted a security interest to the credit corporation in 120 head of cattle that they owned. What they then did in breach of their security agreement is that they decided that they wanted to get out of the cattle business, and they instead thought that they might stave off their impending bankruptcy by farming a different breed of cattle called Watusi cattle. Hopefully this doesn't cause any of you to Google Watusi cattle now, but Watusi cattle are sometimes called the king of cattle. They have these enormous, quite glorious horns. So what Mr. and Mrs. Pettyjohn did is they took the 120 cattle they owned, mixed it with a further number of cattle of about the same amount, sold them all without the permission of the credit corporation, took the proceeds of sale. That's where things get tricky. They used it to pay off an overdraft they held with a different bank. Then they drew down on that same overdraft and used those funds to buy a herd of 66 Watusi cattle. The question for the Court of Appeal is whether the Watusi cattle were proceeds of the original cattle, and thus whether they were identifiable or traceable. Now, if we were to deal with this using the equitable tracing rules, it would be necessary to say, is it possible to backwards trace or trace through a debt through the overdraft into the Watusi cattle? There are different views on whether that's possible. It's received some acceptance in English law, but nonetheless, there's kind of a significant amount of academic commentary that discusses, is backwards tracing possible? And if so, where should we draw the line as to it? However, what the Saskatchewan Court of Appeal instead did is they said it is not appropriate to apply the equitable rules of tracing in interpreting their statute. Instead, what they did is they proposed a new test where they said property will be traceable if it is of like function in the affairs of the debtor, and thus they said, since the Watusi cattle were of a similar function to the business of the Pettyjohns, it's possible to trace from the original cattle. I don't want to be glib, but I do think in essence what that boils down to is those were cows. This is a different type of cow. You should be able to trace and say that it's proceeds. Now, one of the reasons that they said it's inappropriate to use the equitable tracing rules is that they said it would be contrary to the substance over form approach because it would involve formalistic reasoning. And for the reasons I've already harped on about a fair bit, I don't think that reasoning should be accepted. Substance over form, functionalism, has nothing to do with formalism in this more general sense that the Saskatchewan Court of Appeal was using it. And indeed, each of these functionalist secured transaction statutes themselves tend to be extremely formalistic. Now, that's not surprising, right? You would think that a statute governing an area as complicated as the law of secured transactions would itself be fairly technical and complex. But a consequence of that is that it's difficult to see why we should reject the idea that there might be any complexity on the basis that that is formalistic and thus contrary to the substance over form approach. Instead, where this question comes up, once again, it should be addressed from first principles. The question should simply be, well, okay, this has nothing to do with substance over form. What we instead need to ask is there any compelling reason why the rules of tracing should differ under one of these statutes than they do in other circumstances, such as where a trust beneficiary or some other property interest holder is trying to trace from one asset into another asset? Now, here I think the answer is that there are quite compelling reasons why they should be the same. There is a normative basis for the rules of tracing that applies with equal force in the law of secured transactions. It may well be that the rules of tracing are too complex. It may well be that they are themselves problematic and should be improved. But if that is the case, that is a case for reforming all of the rules of tracing rather than just fiddling with them in the particular context of the law of secured transactions. And the last point that points towards this conclusion is that it seems quite odd that we would have different tracing rules that would apply within the statute to ones that would apply outside of the statute. Again, unless there is some compelling reason why they should differ between those two different areas of law. Now, the more general conclusion that I want to draw here, and again, in the written paper, I illustrate this with a further example as well, is that functionalism not only does not do away with the idea of formalistic reasoning more generally, functionalism is in no way inconsistent with adopting solutions provided by the common law to problems that come up in the law of secured transactions. There are some problems when you enact this type of statute that you essentially have to address because they're raised by the statute itself. But then there are other problems, such as when should it be possible to trace from one asset to another, where the common law already has a set of rules designed to solve that problem. If there are no compelling reasons to deviate from those common law rules, there is no reason why such a statute should not simply adopt the existing solution provided to the problem at hand. I'm okay for time. Let me wrap up by reiterating each of these points. Ultimately tonight, I've sought to make 3 points. The first is a functionalist secured transaction statute is not a code. It does not do away with the principles of the common law. It also does not restate the principles of the common law as a whole. These are statutes that we can only make sense of by first understanding common law principles which are not contained in their texts themselves. A corollary of this is that we need to understand the proper scope of their functionalist approach. Functionalism under these statutes is not about doing away with all the consequences of form. It is just about saying, once you're within the statute, the rules apply to your interest regardless of its common law form. The second point is that functionalism in and of itself does not resolve many of the difficult policy questions within these statutes. In a really seminal paper co-authored by Michael over 25 years ago, the conclusion was functionalism is not the answer, functionalism is the question. Building upon that, what I've sought to show tonight is that when you have policy choices that arise in the context of a functional secured transaction statute, you can't just say, oh, well, it's solved by substance over form. You need to consider each of those policy choices on their own merits, as was illustrated with the example of whether a security interest must be legal or equitable for the limited purposes where that remains relevant. And finally, functionalism does not do away with the idea of formalism more generally. Again, the corollary of this is that it will often be appropriate where the common law has provided an answer to a question that needs to be resolved under this kind of statute, to just adopt the solution that the common law provides, unless there is some compelling case otherwise. Now, to zoom back out, the final thing that I'll conclude on, why do we care about this in jurisdictions such as Hong Kong or Singapore or England? This informs whether such a statute should be enacted, in that it suggests that you should not enact a functionalist secured transaction statute based upon an overstatement of what functionalism is actually capable of achieving. Now, I should clarify here, I'm not saying you should or you should not adopt one of these statutes. Ultimately, I think that involves a cost-benefit analysis. It's often going to differ between jurisdictions. Personally, I think there's a lot of force in the point made by the English banking lawyers. Our law of secured transactions works really well. Is it worth risking throwing out the baby with the bathwater? On the other hand, there may be quite compelling reasons in other jurisdictions to enact one of these statutes. In Australia, it allowed us to deal with the difficulty of the fact that our existing secured transactions law was spread across each of our different states. For example, we had different bills of sale statutes in every different Australian state. It was probably not feasible to go to each of the states and say, hey, look, can you reform this incredibly unsexy area of law individually? But it was feasible to say, just refer your power to the Commonwealth and just get rid of that stuff and we'll take this problem off of your hands. Similarly, in the United States, a very compelling reason for enacting Article 9 came about because of the Supreme Court of the United States' refusal to recognize a floating charge. In Canada, they had statutes that further complicated the law of secured transactions, including in respect of reservation of title arrangements, which arguably provided quite a compelling reason to just kind of throw them out and start again with a functional secured transaction statute. So again, my point is not do it or don't do it. My point is, if you're going to do it, don't do so on the basis that functionalism will do more than it can actually achieve. The second point that then flows from this comes about if a jurisdiction is going to enact such a statute. If such a statute is going to be passed, it's essential to bear in mind the need to make some of these difficult policy choices. I think one of the mistakes that some of the jurisdictions, including my own, have made is not to give enough thought to how this sort of statute interacts with the common law. And I think that's quite intuitive. We think of these statutes as kind of doing away with lots of the consequences of common law. So when it comes to enacting them, why would we think really hard about how the common law will continue to operate? But if you're going to enact a functional secured transaction statute without reforming all of the other bodies of law that continue to sit around it, both in common law and equity and other statutes, it's essential to bear in mind how those interactions are going to work and what the policy choices that need to be made within those are. And in doing so, where it's possible to just adopt an existing solution to a problem that needs to be resolved within such a statute, I think there's a lot to be said for focusing on the other problems that must be addressed within them and to adopt the solution that the common law may already provide. I will end there. I hope you found this of some interest and I look forward to any questions or comments you may.